Let's take a look at equal employment opportunity. Government bodies regulate equal employment opportunity and workforce safety and health. There are major laws affecting employers in these areas, as well as agencies charged with enforcing those laws. Organizations can develop practices that ensure that they're in compliance with the law. Managers often want a list of do's and don'ts that will keep them out of legal trouble, rather than learning the reasons behind the rules. Clearly, certain practices are illegal or at least inadvisable. Managers who merely focus on how to avoid breaking the law are not thinking about how to be ethical. All three branches of the U.S. government play an important role in creating the legal environment for HR. The legislative branch, which consists of two houses of Congress, has enacted a number of laws governing HR activities. U.S. senators and representatives generally develop these laws in response to perceived societal needs. For example, during the Civil Rights Movement of the early 1960s, Congress enacted Title VII of the Civil Rights Act to ensure that various minority groups received equal opportunities in many areas of life. The executive branch, including many regulatory agencies that the president oversees, is responsible for enforcing the laws passed by Congress. Some federal agencies involved in regulating HR management include the Equal Employment Opportunity Commission and the Occupational Safety and Health Administration. In addition, the president may issue executive orders, which are directives issued solely by the president without requiring congressional approval. The judicial branch, the federal court system, influences employment law by interpreting the law and holding trials concerning violations. Decisions made by the Supreme Court are binding and can only be overturned by laws passed through Congress. The Civil Rights Act of 1991 was partially designed to overturn Supreme Court decisions. Achieving equal employment opportunity is one of the most significant employment regulation efforts. Equal employment opportunity is the condition in which all individuals have equal chance for employment, regarding of race, color, religion, sex, age, disability, or national origin. The federal government's efforts to create equal employment opportunity include constitutional amendments, legislation, and executive orders, as well as court decisions that interpret the law. The periods following the Civil War and during the Civil Rights Movement of the 1960s were times when many voices in society pressed for equal rights for all without regards to a person's race or sex. In response, Congress passed Title VII of the Civil Rights Act in 1964, a major law regulating equal employment opportunity that's enforced by the Equal Employment Opportunity Commission, known as the EEOC. To counter discrimination against older workers, Congress in 1967 passed the Age Discrimination in Employment Act known as the ADEA, which prohibits discrimination against workers who are over the age of 40. An amendment to Title VII of the Civil Rights Act of 1964, the Pregnancy Discrimination Act of 1978, defines discrimination on the basis of pregnancy, childbirth, or related medical conditions to be a form of illegal sex discrimination. One of the farthest-reaching acts concerning the management of human resources is the Americans with Disabilities Act. This 1990 law protects individuals with disabilities from being discriminated against in the workplace. There are many other equal employment laws passed by Congress that affect human resource management. It's important for HR managers to be familiar with their impact. Two executive orders that directly affect HR management are Executive Order 11246, issued by Lyndon Johnson, and Executive Order 11478, issued by Richard Nixon. Executive Order 11246 prohibits federal contractors and subcontractors from discriminating based on race, color, religion, sex, or national origin. Executive Order 11478 requires the federal government to base all of its employment policies on merit and fitness. It specifies that race, color, sex, religion, and national origin may not be considered. The U.S. Office of Personnel Management is in charge of ensuring that the government is in compliance. At a minimum, equal employment opportunity requires that employers comply with EEO laws. The Equal Employment Opportunity Commission is responsible for enforcing most of EEO laws, including Title VII, the Equal Pay Act, and the Americans with Disabilities Act. When individuals believe they've been discriminated against, they can file a complaint. The EEOC investigates and resolves complaints about discrimination, gathers information, and issues guidelines. If the EEOC determines that discrimination has taken place, its representatives will attempt to work with the individual and the employer to try to achieve reconciliation without a lawsuit. The EEOC also monitors organizations' hiring practices. Each year, organizations that are government contractors or subcontractors must report something that outlines the demographics of employees in each job category. The EEOC analyzes these reports and identifies patterns of discrimination, which the agency can then attack through class action lawsuits. Employers must display EEOC posters detailing employment rights. Besides resolving complaints and suing alleged violators, the EEOC issues guidelines designed to help employers determine when their decisions violate the law enforced by the EEOC. The Office of Federal Contract Compliance Programs, or the OFCCP, is the agency responsible for enforcing executive orders that cover companies doing business with the federal government. Employers can also avoid discrimination and defend against claims of discrimination by establishing and enforcing an EEO policy. The policy should define and prohibit unlawful behaviors, as well as provide procedures for making complaints. Most companies recognize the importance of complying with EEO law. Decisions about HR are so complex that discrimination is often difficult to identify and prove. However, legal scholars and court rulings have arrived at some ways to show evidence of discrimination. One potential sign of discrimination is disparate treatment. Differing treatment of individuals, where the differences are based on the individual's race, color, religion, sex, national origin, age, or disability status. To avoid disparate treatment, companies can evaluate the questions and investigations they use in making employment decisions. These should be applied equally. Another way to assess potential discrimination is by identifying disparate impact, a condition in which employment practices are seemingly neutral yet disproportionately exclude a protected group from employment opportunity. To avoid declarations of practicing illegally, an organization must show that disparate impact caused by the practice is based on a business necessity. Proving disparate treatment in court requires showing that the employer intended the disparate treatment, but the plaintiff needs to show the intent in the case of disparate impact. It's enough to show that the result of the treatment was unequal. Employers can also avoid discrimination by defending against claims of discrimination established by enforcing an EEO policy. The policy should define and prohibit unlawful behavior, as well as provide procedures for making and investigating complaints. The policy should also require that employees at all levels engage in fair conduct and respectful language. The EEOC defines sexual harassment of employees as unlawful employment discrimination. Sexual harassment refers to workplace conduct of a sexual nature that's unwarranted or unwelcome, whether verbal or physical. Managers must understand what they can do to monitor and create respectful work environments within their team. Like equal employment opportunity, the protection of employee safety and health is regulated by the government. Through the 1960s, workplace safety was primarily an issue between workers and employers. By 1970, however, roughly 15,000 work-related fatalities occurred every year. That year, Congress enacted the Occupational Safety and Health Act, which authorized the federal government to establish and enforce occupational safety and health standards for all places of employment engaging in interstate commerce. The main provision of the OSHA Act states that each employer has the general duty to furnish each employee a place of employment free from recognized hazards that cause or are likely to cause death or serious physical harm. This is called the Act's General Duty Clause. Employers must also keep records of work-related injuries and illnesses and post an annual summary of these records from about February 1st to April 30th in the following year. To enforce the Act, the Occupational Safety and Health Administration conducts inspections. OSHA compliance officers typically arrive at a workplace unannounced. Following an inspection, OSHA gives the employer a reasonable time frame to which they can correct the violations identified and imposes fines. Although the Occupational Safety and Health Act makes employers responsible for protecting workers from safety and health hazards, employees have to follow OSHA's safety rules and regulations governing employee behavior. Employees also have the duty to report hazardous conditions. They can file a complaint and request an OSHA inspection of the workplace, and their employers may not retaliate against them for complaining. The Occupational Safety and Health Act has unquestionably succeeded in raising the level of awareness of occupational safety, yet legislation alone can't solve problems of workplace site safety. Many employers go beyond the letter of the law to achieve stronger results in workplace safety. Many employers establish safety programs that go beyond the mere compliance and attempt to install an emphasis on safety. Employees, supervisors, and their knowledgeable sources need to sit down with and discuss potential problems related to safety. One method for doing so is the job hazard analysis technique. With this technique, each job is broken down into basic elements, and each of these is rated for its potential for harm or injury. If a particular task has a high hazard potential, the group isolates the element and considers possible technological or behavioral changes to reduce or eliminate the hazard. Another means of isolating unsafe job requirements or elements is to study past accidents. The technique of operations review is an analysis method for determining the specific element of a job leading to a past accident. Job analysis may be entering a new level of sophistication thanks to the development of wearable devices that contain sensors and monitors for gathering and communicating data related to worker safety. To ensure safe behaviors, employers should not only define how to do work safely, but reinforce desired behavior. One common technique for reinforcing safe practices is by implementing a safety incentive program. Training programs and incentives should take into account workers who are at the greatest risk of injury.